Hello everyone, welcome back to my channel, and in today's video I will be dealing with the topics of Privy Council and Federal Court. So in short, to tell you regarding what Privy Council and Federal Court is, so it is basically what today's Supreme Court plays the role of judiciary in India. But what was the situation before the coming of Supreme Court, before establishment of Supreme Court, is what Privy Council and Federal Court is all about. So Privy Council originated according to the principles of Norman Conquest, who has shaped English law and given the concept of curia regis. So what curia regis exactly means? It's a Latin term. It means kings in council. So basically this word itself defines that it is the highest authority on highest level who controls the judicial powers is kings in council. So there are mainly three divisions given by Henry II for hearing appeals. We all know that there is original jurisdiction, appellate jurisdiction, testamentary jurisdiction, different types of jurisdictions. But for Privy Council, for hearing appeals, three types of divisions were given by Henry II. And many acts established judicial committee in Privy Council, because the thing was, at that time there was not well educated people in law, so there were laymen. For them, this acts established judicial committee. So what exactly were the composition of Privy Council? So there were mainly four main significant people, first being the Lord Chancellor, then Lord President, Privy Councillors, and Lord of Appeals. So these were the designations in Privy Council. Then what was the jurisdiction of Privy Council? What spheres exactly jurisdiction the Privy Council covers? First, it covers the appellate jurisdiction. So in India at that time, we saw that there was establishment of mayor courts. So where exactly a person goes if he is not satisfied with the decision of mayor court or admiralty court? He goes to Privy Council. That is the appellate jurisdiction of Privy Council. It was the highest court of appeal, and from anywhere in the British colonies, if certain person is not satisfied by the decision of the competent court, he can come directly to the Privy Council. And this played a very important role in the developmental years of 1726 till 1749, as it was very unique in nature because it contributed in the judicial system. But then again, there were problems with Privy Council. It was not perfect. First problem was there were only English judges, and it was situated in England. So Privy Council situated in England. Person from India wants to go to Privy Council, but he cannot, because there is a problem of mobility. If you are not satisfied, if someone is poor, he doesn't have that much money to take his matter, go to the Privy Council, do back and forth every time single matter is listed, he has to go to Privy Council. That was a problem, and it was very less mobile. Then the British judges in Privy Council were unaware about personal laws. They were not even considering whether personal laws exist in that country or not. They were just imposing English laws, and they were very partial in nature. So just take an example. If certain matters are filed in East India Company, you would take that matter to Privy Council. So there is a cognitive bias against the person, and they will be biased towards East India Company. So this was the partiality that was there. Then again, after Privy Council, Federal Court. But exactly Privy Council, why it was abolished is during the independence, it was noted that there is a need to abolish Privy Council because of all of the defects and all. But before that also, in Government of India Act of 1935, this was called as the mini constitution because the entire base of constitution was taken from this act. So this act of 1935 has established Federal Court, abolishing the Privy Council. As we all know, there are defects. Privy Council is not perfect, which is the reason, by the recommendation of Sri Hari Singh, who suggested on 1st October 1937, and he was the first person to suggest this, that why go to England for appeals? It is not possible for every time to go to England for appeals. So he suggested this, and it was implemented. And the first Chief Justice was Sir Maurice Guire, and there were 2 puisne judges to assist him. So how were these judges exactly appointed? Is first Chief Justice and not more than 6 puisne judges, and the tenure was till age of 65 years. And the qualifications were exactly 5 years of experience as either High Court judges, or a barrister for 10 years, should be a barrister for 10 years, or for 10 years he should be practicing as a pleader. This was the Federal Court, and the salary was for 7,000 rupees for Chief Justice and 5,000 for other puisne judges. So jurisdiction exactly, this has a broader jurisdiction than Privy Council. So it has original jurisdiction also. So that is basically constitutional matters. As Government of India was a constitutional statute, certain provisions, if violative of the rights of the people, you can argue constitutional matters and take the constitutional cases to federal court. You do not need to go to Privy Council, you directly go to federal court. So original jurisdiction, then advisory jurisdiction. If certain legislative or executive authority advises something, then if that advisory body commits some mistake, you can take action, or if that advisory body is abusing their powers, you can take action and go to the federal court. Then for appeal, there was constitutional cases, civil and criminal, as it is given from lower courts to upper courts. And again, it passed judgments according to CRPC and CPC. So that is basically following the criminal and civil laws that were existed, which were drafted and passed in 1800s. Then again, this has again evolutionized to Supreme Court, as in the Indian Independence Act of 1947, which increased the jurisdiction of federal court also, and abolished the Privy Council system in its entirety and gave full authority to federal court. But then again, due to the problems of federal court, because it is not a federation, federal court, though the word suggests it is not perfect, it is not a federation, and it is incomplete with limited functionalities. Therefore Supreme Court was established, had more powers than federal court. This was the evolution of the highest court from the Privy Council coming to federal court, then coming to Supreme Court. And with this I have concluded this topic, the evolution of the highest court of appeals and highest authority of judicial body. The link of this PPT will be also given in the description. Thank you for watching.